Hello, good afternoon and welcome back. I hope you enjoyed your lunch and took the opportunity to visit our online exhibition area, chat to some of the sponsors, maybe chat to some of the other people who are attending the conference at the same time. This final session, we're going to examine a few of the most prominent data protection trends from 2020 and the associated challenges which faced practitioners. Our first speaker this afternoon is Toby Hayes, who's Global Data Protection Controller for Platis Globalt. And the title of his talk, rather alarmingly, is When Consent Just Won't Cut It. Toby.
My name's Toby Hayes. I'm delighted to join you for this panel session. As Mark said, I'm Data Protection Controller for Platis. You probably haven't heard of us, but you will have heard of our snack brands. So those include McVitie's, Cars, Jacobs, Crawford's. There'll be a virtual Jaffa cake for whoever spots the most references on the shelf behind me. 3 years ago, I was fortunate enough to address this conference up in Edinburgh back in the before times when we could travel to events. And that's where I talked about dumb ways to fail at GDPR. And one of the pitfalls I described back then was the mistake of assuming that you need consent for all of your processing. And this was driven by two particular experiences. Now, the first was a government lawyer some 15 years ago who said to me, if you're designing a system around consent, then you've already failed. Now, that's not the most privacy positive view, but there's an awful lot of truth in there, particularly for someone working in government. The second experience, which I'm sure many of us had, was the so-called GDPR experts who popped out the woodwork in 2016, 2017, telling us that we all needed consent for every bit of processing. And of course, we all know that that's not true. So, given the changes that 2020 has brought for all of us, I'm going to focus on how you can process special category personal data without having to rely upon explicit consent. We'll look at some of the examples that have come up this year and what our lawful basis options are. And please note that what I'm talking about here relates principally to UK processing. Obviously, local laws can force variations in other territories. So if anyone's a little bit sleepy after lunch, a quick reminder of what constitutes special category personal data. We should, of course, all be familiar with these categories. GDPR added the genetic and biometric categories to the list, and it also recognises additional safeguards for personal data about children and criminal history. We should also remind ourselves of our lawful basis for processing. So with special category personal data, we're all aware that Article 9 GDPR prohibits processing of special category data unless you have both a lawful basis under Article 6 and a separate condition for processing under Article 9. And it can be very easy to forget that you need both of those. I've done it myself, I've seen it done elsewhere. And in addition, of course, the UK's Data Protection Act 2018 Schedule 1, I'm sure you're all familiar with that beast, defines conditions and exemptions for processing special category data. So those Article 9 conditions, again, I'm sure we've all familiarised ourselves with this list. The two conditions that are of particular interest for most of us seeking to process without the requirement for explicit consent will be employment, social security and social protection, and in the world of 2020, public health. Now you'll see that I've highlighted B, H, I and J, since they also have extra conditions which are defined in the Data Protection Act Schedule 1, Part 1. But do remember that all of these carry their own conditions, caveats and exemptions, and that local laws can still override them. So, for example, employers in the Netherlands are not permitted to process special category personal data about employee health or ethnicity, except in very specific circumstances. So those additional safeguards, they're defined in Schedule 1, Part 4. And they require a controller wishing to use these non-consent conditions to have what's known as an appropriate policy document, which is an extended privacy notice. And that will actually explain what the controller does to secure compliance with the privacy principles. It explains policies for retention and erasure of personal data. We have to maintain that appropriate policy document and make it available if required. And of course, it requires us to have our records of processing in order, which we should hopefully all have anyway, and complete and maintain a data protection impact assessment. And as was said earlier, a DPIA has to be a living document. It's not a one-off form-filling exercise. You have to maintain it and live up to it. So let's quickly look at a few scenarios that 2020 has thrown our way. So the growth of the Black Lives Matter movement resulted in hugely increased awareness of equality, diversity, and inclusion issues. And it's pushed those up the corporate agenda. So I'm sure many of us in data protection roles have been asked some fairly tricky questions about processing equality data and what's required to do that. So we'll look at a couple of examples on this. So the first purpose I'll look at is, do we require consent to monitor and report on gender pay? I'm not going to do this as a poll, but hopefully you've already got some thoughts going here. The answer is no, and hopefully this is an easy one. So gender isn't special category personal data, which means we don't have to find an Article 9 condition to rely upon for the processing. For companies over 250 employees in the UK, it's a mandatory requirement. So the lawful basis we can rely on is Article 6(1)(c). So this is compliance with an external legal obligation. For smaller companies, that lawful basis doesn't apply. But I think it's entirely reasonable then to rely on Article 1F, which is your legitimate interests, so long as they then offer an Article 21 option to object to processing for this purpose. But the point being that if you completed a legitimate interest assessment, there should be no reason why you can't report on gender pay requiring consent. So you can't report on gender pay in the absence of consent. You shouldn't need consent to do that. Hopefully that all made sense. Otherwise, the next one's going to become tricky. So scenario 2, equality, diversity, inclusion. How do we get to the thorny bit, which is measuring equality of opportunity based upon ethnicity, for example? Do we require consent to do that? Again, I would argue in most instances, the answer to that is no. So obviously ethnicity is special category personal data, and that means we require both Article 9 and Article 6 conditions in order to be able to do so. Now, the law doesn't demand that we monitor this, so our Article 6 condition will be our legitimate interests in order to provide equality within the workplace. We also have to provide the Article 21 option to object to processing if people don't wish to be measured for ethnicity purposes. And that must mean, of course, that providing the data is optional. So we can't in any way coerce employees to provide it. Now, our Article 9 condition will be an obligation in the field of employment. That will specifically then use the exemption that's allowed for us in the Data Protection Act. I'll wave that at you again because it's really worth having a printed copy to hand. Schedule 1, Part 2, Paragraph 8 really clearly lays out those conditions of what data you can process, and also reiterates the right to object to that processing. Now, if you're going to rely on that, don't forget to read ahead to Paragraph 9. That applies further restrictions if you're using ethnicity to determine the senior management composition of your organization. So literally, if you're looking at boardroom or senior management promotions or hiring and firing, If you wish to use ethnicity as part of that decision making, make sure you've read that paragraph 9, because it defines some very specific rules for it. So obviously, the other big ticket item from 2020, COVID-19, that's certainly for myself, like many others, forced a big rethink about how we handle special category personal data and what we can and should do with it in order to protect our customers, our employees, our visitors, our guests. And the question is, can we protect our employees by tracking their COVID exposure? So, for example, where they volunteer COVID-19 test results, or they may phone in saying they've got symptoms, they wish to self-isolate. It may be that they submit GP fit notes confirming that they've tested positive. Do we require consent to process that? Once again, I would argue no. So physical health is clearly special category personal data, so we require Article 9 and Article 6 conditions. But our employees are already contractually obliged to report absence from work on health grounds. That's a normal process. Most companies should have established protocols for doing so. So that means that we can rely on Article 6(1)(b), which is the contract of employment, and Article 9(2)(b) or even 9(2)(h) for processing the health data. So we've now found a way through that, because they have to tell us why they're off work. We've already got that means of reusing the data. Now, of course, reusing it for tracking and tracing COVID within the workplace, that's repurposing. But we don't need consent to do so, because we can do that under Article 9(2)(g), so long as we also meet the requirements laid out, handy prop again, in Data Protection 2018, Schedule 1, Part 1, Paragraph 3. And it very clearly makes provision for that. So you've got the means to protect your workforce without having to go through a consent process to do so. The next area that many of our organizations would have jumped into with COVID, and I'm sure we've all been through it, is the use of remote body temperature screening. So having reception desks or security tooled up with a little remote body temperature scanner and asking people to declare COVID symptoms or recent travel or family household exposure to COVID. So, do we require consent to do this? Hopefully you've already got an answer in mind, as we're not running it as a poll. But, trick question, don't collect the data. You don't need it. So all of that can be achieved without any personal data collection. So what we do at our sites is to ask anyone coming in, be they employee or visitor, we ask them about potential exposure, we ask them about potential symptoms. We then take their temperature with a remote body temperature sensor. That's not a clever remote piece of kit. It's the security guard or receptionist with a little handheld temperature checker. But we don't collect any data at all. If they answer that they may have been exposed, or they have a cough, or they're showing an elevated body temperature, we simply ask them to leave the site and call in through the normal sick protocols. Or if they're a visitor, to call the person that they were visiting and say, I've not been able to come on site for this reason. So we're not collecting any structured data here at all, or any data, indeed any data at all, with relation to the body temperature scanning. The last one, let's come to, given that it's December, and this one's doing the rounds again, can Santa Claus maintain a list of who's been naughty or nice without breaching GDPR? Now, there's various versions of the list that you'll see on the slide there, which makes me laugh because it's breaching GDPR Article 4, so it claims. Now, GDPR Article 4, I'm sure we all know, defines the terms that apply to the legislation. So clearly that's not a breach. I'm going to offer a slightly different view from some others you may have seen on this processing. So let's assume that letters sent up chimneys or given to Santa Claus in a shopping mall are indications of membership of the Santa Claus Club from children. So they're indicating that, yes, I want to sign up with Santa Claus. Clearly, if you look at his origin story, it's a religious or spiritual origin to that, regardless pretty much of which culture's version you go with. St. Nicholas certainly was a saint with Turkish origins, which is very appropriate for our company. So if we assume that North Pole Enterprises is a religious or spiritual membership body, then it's reasonable to argue that Santa is acting in the course of his legitimate activities. Obviously, he needs appropriate safeguards in place, but he can operate without that consent under Article 6.1F, legitimate interests. And indeed, if there's any special category data in there, under Article 9.2D, which again specifically caters for that processing. But I do appreciate we're dealing with children's data here, so there's many layers of potential complication. And if anyone wants to pick that up in a discussion room afterwards, I'd be delighted to do so. So finally, to end out, before you go for consent, remember that it may seem the most desirable way to process. There's no question that ethically it is generally the best one to go for, but it can often be the most difficult lawful basis to live with. So have a think about whether it's really appropriate, and then think about, do you need special category personal data to achieve the outcome that you're after? Is there no other reasonable or less intrusive way to achieve it? Have you got your Article 6 and Article 9 conditions for processing? And have you put in place the various safeguards that you're required to do so under GDPR and indeed Data Protection Act 2018? Now, in preparing that, I have shamelessly cribbed the ICO's website, which is a fantastic starting point for anyone looking for a lawful basis for processing without having to go for consent. So hopefully that's given you some ideas for how you can move forward with the last 2 weeks of 2020 and whatever it may throw at us. In the meantime, thank you for your time, good luck, and I'll hand you on to the next session.
Toby, thank you very much for that. Again, plenty of food for thought in amongst that. Our next speaker, before I get to the next speaker, I should just remind you of the possibility of asking questions. Use the utility of the screen. There's some questions up there already later. Our next speaker is Vivian Arts, who's the Chief Privacy Officer for Refinitiv, looking at data localization in the global world. So, Vivian.
Thank you very much. Can you see me now? I can't see. I don't think I'm on the bridge yet. Yes, we can see you. Great, sorry, just a technical hitch there. I couldn't quite see myself. There we go. So hello, everybody. I'm absolutely delighted to be here. The topic I want to talk to you about today is one that is hugely relevant for us all. It's data localization in a global world. So let's start with types of localization. There are many types of localization which we're going to explore, but there's also a couple of distinctions that I think it's important to make in the first instance. The first one is, what is data localization? And basically, it is a mechanism that requires data to be stored in the country of origin. Whereas data sovereignty is the concept that a country has control over personal data that was either created or collected in that country. So an example of data sovereignty is the US Patriot Act, which enables US officials to access any information that is physically found within a server in the US, regardless of where the information had originated. And this is incredibly important because digital trade and data flows underpin basically and drive business and trade globally. An interesting statistic is that in 2018, digital services exports for the UK amounted to the total value of £190 billion, which just gives you a sense of the scope and the scale. So what are the drivers for data localization? Would countries want to localize data, given that we rely on the free flow of data to promote trade on the internet, to promote trade between countries, to facilitate services, to allow our clients to access global services and functions, as the case may be? We live in a globalized world. Everyone needs access to data. So why are we seeing an increasing trend for data localization? Part of this is because we're seeing varying levels of protection of personal data across different jurisdictions. If you put your mind back about 20 years, then there were probably less than 50 countries in the world that had data protection laws. Today, there's over 130 countries have data protection laws. And what's interesting there is you would think that with more countries having data protection laws, that you would end up with greater similarity and, in fact, I suppose, a greater ability to share data because of the enhanced safeguards. In fact, it's led to greater fragmentation and more challenges with regard to the transfer of data rather than creating a data sharing community. Otherwise, there are concerns around breach of data protection through access to data. So there's a lot of concern, and we've heard of a number of high-profile cases, for example, where there is concern about government access to data when it is sitting in a third country. Another concern that drives data localization is one by regulators who feel that if the data isn't physically stored in the country where to which it relates, that actually they might have difficulty accessing the data if it is stored overseas in another place. So it's how do regulators get comfortable with their need to access data quickly and efficiently? The other reason is there are varying standards of data security and breach response obligations across jurisdictions, and that can give rise to concerns. And then there's also a concern of the impact of foreign businesses on local businesses and markets. So one of the reasons that's often given for data localization is that data ought to be localized because it can help promote skills and opportunities within the local market, as opposed to relying on the remote business, which is providing those services into the jurisdiction, as the case may be. So those are some of the drivers for data localization, and you can imagine that some of them do seem to be quite fair, really. But what is the impact? So let's have a look at, in a little bit more detail, what are the different types of localization, because they do vary. And it isn't all just about data protection either. So sometimes the localization takes the form of a requirement to have equivalent standards. So while equivalent standards sounds a very sensible thing, I'm not going to transfer the data from A to B unless we share the same standards. Very sensible. But the reality is what we're seeing is that those standards are not about being adequate, but they are literally about being equivalent. And the reality of the world in which we live is that each jurisdiction has its own laws, has its own principles, etc. And as a result, you're never going to actually reach absolute equivalence because legally, philosophically, culturally, every country operates slightly differently. The next type of localization is consent restrictions. We've actually just heard an awful lot about consent, but in a number of jurisdictions, we're seeing that data cannot be exported unless the individual consents. The reality is that consent isn't the be-all, end-all, and it ignores often the fact that consent is not feasible or is not able to be achieved. So, for example, if you're a payment services provider, you're in between the customer and perhaps the merchant and the bank at the other end. You're providing the the mechanism for the payments to be transferred, you do not have the ability to obtain consent from the individual. They're not your client. The merchant and the bank are your client. So consent is a type of data localization, and it's one that can produce some very real practical challenges. It isn't just the challenge of getting the consent. Very often the consent is just not feasible to obtain in the first place. Some jurisdictions are really just quite clear, and they say that you can't transfer the data, full stop. So, there's rules that say that it just can't leave the jurisdiction at all, and has to stay in the jurisdiction. We often see that in relation to anti-money laundering requirements. There's certain types of data that just have to be held locally and cannot be transferred. Local copy rules. An excellent example of local copy rules is Russia, actually, where a copy of the data needs to be held locally in its country of origin. There's a number of jurisdictions that have a requirement for local copy rules. Sometimes it relates to personal data, sometimes it relates to financial data. It can vary. It's an inconvenience, but it's not the end of the world because it doesn't prohibit the transfer of data. It just requires you to duplicate and hold another copy locally. Another area is outsourcing restrictions. So we see a number of jurisdictions where the outsourcing restrictions are so strong that it does create a need to provide the services in jurisdiction, and they can't be provided from outside of jurisdiction. It's been used in a number of jurisdictions, usually driven by a want by the regulator to access the data or to ensure controls over the data. But outsourcing restrictions are another mechanism, and of course that goes well beyond personal data as well. And then the other piece of it is non-personal data restrictions. And we can see, for example, in the proposals in the Indian legislation, where they are proposing both the data protection law as well as restrictions on non-personal data, that there is an increasing interest in restricting the flow of non-personal data as well, recognizing that it might be sovereign or national data and it needs to stay within jurisdiction. This is a map just to show where some of the existing data localization laws are today. As I said, it's evolving very, very quickly, but ones that we know very well are China, Indonesia, Nigeria, Russia, Vietnam, and Brunei. So thanks very much for the chance for this particular map. But there are also now many more countries which are will have data localization provisions. And even if they're not specifically called a data localization law, they may very well have the impact of restricting the flow of data. So emerging areas of data localization would be in the EU. There is a new proposed directive called the Directive for Operational Resilience. DORA, as it's fondly referred to, is a piece of legislation that is focused on operational resilience, but one of the criteria is that firms in the EU would not be able to use a service provider who did not have a presence in the EU as well. The restrictions and obligations imposed in DORA are quite significant. And so although it doesn't explicitly say that it's a data localization piece of legislation, the impact may very well be that it has that effect. GDPR has often been referred to as being a piece of legislation that is very focused on data localization. And that's because the transfer restrictions in Chapter 5 are quite onerous. It tends to take a case-by-case process or a view to data transfers, and it can be quite difficult sometimes to meet those standards. And we can see that specifically with the recent developments, the Schrems II decision in July, and now the EDPB has issued its 6 steps and the European Essential Guarantees for Surveillance Measures, which is its guidance following the Schrems II decision, which Caitlin will go into in significant detail. So I won't spend too much time on it here, but suffice to say that when you've read those provisions, it is increasingly difficult for firms to transfer data outside of the EU. If you do, the compliance requirements are so significant that it does actually cause firms to stop and pause and think about whether or not actually it isn't just simpler, cheaper, and easier to keep it in the EU. We also have the European Commission standard contractual clauses, which have just been published, which now provide 4 different formulas for transferring data as opposed to the previous 2. Again, if you read those, there are a number of obligations in there that, again, create additional hurdles for organizations to transfer data. And then again, we've got the EU Data Governance Act, which has just recently been published. It was slightly amended from the original version, which was quite clearly focused on data sovereignty, technical sovereignty, and an impact of data localization. It's a bit softened now, but nonetheless, it is still promoting very much a European community of data, and one that is keen to ensure that only European standards would apply to that data. India, as I mentioned, has the personal and non-personal data draft law that's making its way through Parliament. I think they were hoping to pass that at the end of this year, but with COVID and other things, that looks likely to be delayed until 2021. There's been a lot of thoughts and views shared with India about the impact of such a provision, but they look pretty wedded to heading down that data localization route. So we'll see what happens there. And then China, although they already have a localization requirement, they too are proposing new cybersecurity laws and recently a draft privacy law, which will further strengthen the data localization obligations in China. So what is the practical impact of data localization on the financial services sector? Well, basically, it's adding huge layers of complexity and regulation to the flow of data, which is particularly unhelpful. I gave you the statistic earlier on, which was, $190 billion or pounds is the value of digital services exports for the UK. And actually, UK financial services sector constitutes 89% of digital trade from the UK. So that you can imagine that a restriction on the flow of data is very, very significant. If it becomes too challenging to transfer data, it can actually stifle local investment. So at the end of the day, firms will look at a particular jurisdiction and work out the revenue opportunities. If I do business in jurisdiction A, this is what I would hope to see in terms of revenue, but this is the cost of compliance. And you have to weigh the two together. And the cost of compliance is the same or higher than the revenue opportunities, then it would clearly not be a sensible business decision to go there. So it can actually stifle local investment. There's also the challenges of navigating both the risks associated with data localization to make sure that you're actually able to comply effectively, and also the challenges around your legal liability as well. And then the third thing is that it does lead to inconsistent and conflicting obligations. So it's been often discussed that regulators, particularly in the financial services sector, want transparency and access to data in a ready and forthright manner. They want to have a single customer view, for example. Data localization obligations mean that data becomes fragmented, and actually you can't necessarily have a single or full customer view, as the case may be. And this is particularly important when you think of the fight against financial crime, the need to share information globally in relation to clients and transactions, and also in relation to cybersecurity risk, just by way of 2 examples. The other part is that regulatory oversight would be inhibited rather than improved. So regulators actually would need to understand the full breadth of the risk that an organization might be facing, but if they can't see certain areas of data, if certain areas are basically, it's a bit of a black hole, shall we say, in terms of the overview and visibility of risks and presence, then that inhibits the regulator's view to see that information and to regulate effectively. When you're storing data in multiple places as well, it can enhance rather than limit data security and cyber threat risks. If you store data centrally, which is where many firms have been going in recent years, you can focus your budget and your attention on improving data security in relation to those particular areas. If you're having to set up multiple data centers in multiple jurisdictions, you're creating not only duplication of data, but also duplication of costs, and there's really only ever a finite budget. So you end up spending more, and it's spread out a little bit more thinly. And then finally, of course, there's the impact on the customer. All of these additional costs would be eventually flowed down to the customer. And of course, there's also the challenge of the, I suppose, the speed of service and agility in meeting customer needs. If data's got to flow through many different processes and overcome many different hurdles, it becomes less seamless and agile in terms of that overall experience. So through the data working group of the IRSG, so I chair the IRSG data working group, we recently, earlier this week actually, just published a paper on data localization and the impact. And we came up with a number of recommendations, which I'd like to share with you today. So the first one is that we should have a principle-based approach to data protection. So jurisdictions should acknowledge and adhere to core principles of data protection standards and safeguards across different legal jurisdictions, and we should be looking to mutually recognize on a multilateral basis to provide assurance that data will be sufficiently protected. So rather than taking a bilateral, are you equivalent type of approach, which I think focuses more on the differences, and there will always be differences, we're encouraging governments to actually look at where do we find similarities. Can we focus instead perhaps on the outcome of those provisions as opposed to the nitty-gritty details, as the case may be? The other recommendation is to address regulatory concerns by rules on access rather than localization. So, for example, outsourcing regulation should seek only to ensure that control of or access to information and ultimately the responsibility for the data remains that of the local regulated entity, and that such is legally documented in the relevant contract with the outsourcing provider. So there are ways in which you can secure the access of the regulator to the data. That doesn't mean that you have to store it locally. So contractual assurances both with the local entity as well as the outsourcing provider can absolutely achieve that. Operational resilience should focus on the quality of outsourcing, again, and not the location, which is what we mentioned earlier, which is it's not the location that's going to assure security. It's actually looking at the broader operational resilience of the relationship. Increased cooperation at an international level is encouraged. So jurisdictions should work together to recognize that equivalent standards for data protection do not necessarily translate as the same standards for data protection. And increased cooperation may ensure that appropriate proportionate regulatory access to data is maintained. So where we're coming out here is that actually we should be looking at collaboration with regulators to ensure that they have cooperation and access where needed. So rather than a broad brush prohibition on the sharing of data, why not focus instead on putting in place those arrangements which would address the concerns and allow specific access to data where appropriate. And then the use of international trade agreements to remove barriers. Traditionally, data has been excluded from trade agreements for lots of different reasons, but increasingly we're seeing data now as part of trade agreements. So in the UK-Japan SEPA agreement, there's actually a commitment by the UK and Japan not to engage in data localization practices. And that sets a really useful precedent for trade agreements going forward, is to promote trust, to promote the flow of data, and to ensure that data is an enabler for trade rather than a barrier. So with that, I am going to hand over to the next speaker. Thank you so much.
Thank you very much, Vivian. That was kind. Thank you very much, Vivian. That was kind of you. Our next speaker is Caitlin Fennessy, Research Director for the International Association of Privacy Professionals. And Schrems II has already been mentioned this afternoon. She's going to be looking at that and global data and asking the question, what's next? So, Caitlin, over to you.
Thank you so much. I'm waiting to see myself as Vivian did, so just want to make sure we're all set on that front. Hopefully you can all see me now. So thank you very much for inviting me to speak, and I'm just delighted to join this thoughtful group of speakers, and I'm actually quite struck by the intersections between Vivian's remarks and my own. I think you will find that mine very much build on hers, which is also just amusing, since I did not know the details, of course, of her presentation, but found them quite thoughtful. So I'm going to focus today on Schrems II and global data, looking at the implications, what we are seeing in practice, as well as what might come next. So at this Okay, so I am going to switch, I believe, to just audio, since I understand we're having trouble. All right, so let me do that. Excuse me. Okay. So at this point, I expect you are all quite familiar with my topic, the Court of Justice's Schrems II decision, which Vivian herself mentioned earlier. So I assume you're familiar, and so I will just touch on it briefly before turning to the implications. As you likely know, the July 16th Schrems II decision invalidated the European Commission's adequacy determination for Privacy Shield and upheld standard contracts, but with some major caveats that I want to focus on today. So the main reasons that I'm sorry for my hesitation. I just wanted to make sure everything on the technical side was fine. All right, I understand now it is. So let me dive in. So in terms of Schrems II, the invalidation of Privacy Shield was deemed insufficient for two main reasons, those being that the court judged the assessment that U.S. protections governing national security access to data did not meet EU necessity and proportionality standards and did not provide actionable redress. It upheld standard contracts, the most common and frequently used mechanism to transfer data out of the EU globally, but with some big caveats. Basically, that the data exporter, in cooperation with the importer, must conduct case-by-case assessments of whether foreign protections meet EU adequacy standards. So yes, basically the court said that the standard for standard contracts is the same standard in practice as that for the types of adequacy determinations that the Commission itself conducts. So where standard contracts can't provide that, or where the country in question to which the data is transferring, where the laws would impinge on the importer's ability to meet those standards, the exporter is required with the importer to put in place additional safeguards to meet that standard or suspend transfers. And the court called on DPAs to suspend transfers if the company itself doesn't. Unfortunately, it didn't further explain what additional safeguards might entail in practice. So I want to look at what has happened since the ruling itself. So data flows certainly didn't stop, but the decades-long uncertainty surrounding them did intensify. Initially, we saw DPAs across Europe take different positions, particularly with regard to transfers to the US. Some DPAs said data could still flow using standard contracts. Others said it was questionable, and others said it couldn't. They did importantly later issue collective guidance saying that the data could flow, including to the US, as long as there were sufficient safeguards provided. But at that point, they didn't yet address what those safeguards might entail. They agreed that this was not just a US issue, importantly, and that the court had called for case-by-case assessments for transfers globally using standard contracts and other mechanisms, at least where there isn't an adequacy determination. So as we all know, I presume, on this call, that means most of the world. The EU has 12 currently applicable adequacy determinations, and so that leaves most countries and most data flows uncovered by them. In fact, 150 plus countries and over 65% of the global economy. So I think just thinking about this in practice, that is a lot of case-by-case assessments for companies to conduct, and points to the type of fragmentation, even on just the EU level that Vivian spoke of earlier. So I want to look in more detail at how companies have responded to this. With Privacy Shield no longer sufficient for its 5,000 plus participants, companies have turned to a narrowed set of alternatives once again. As we know, many have switched to standard contracts. They've launched case-by-case assessments, now termed transfer impact assessments, or TIAs. And they've put in place 3 sets of additional safeguards: those that fall into the technical category, contractual safeguards, and organizational safeguards. They've also looked more closely at Article 49 derogations as a basis for transfer. But while they're doing all this work, putting in place these additional protections, they also recognize that the whole landscape stands on shakier ground following the ruling. So at the IAPP, we frequently survey privacy professionals around the world to try to understand what is happening in the market in practice. And we did that this summer immediately after the court ruling as part of our annual privacy governance survey, which actually is about to be released next week. And so I'm sharing a little data with you ahead of that. We found that 65% of respondents transferred data out of the EU. And of those, the vast majority, 88%, rely on standard contracts. Looking more at the implications of the Schrems II decision, we found that a full 62%, even more than the 55% relying on Privacy Shield, said that they plan to adjust their transfer mechanisms as a result of the ruling. Of course, that's no big surprise, but it's interesting to look at what they are switching to. So most plan to switch to standard contracts, of course, with few other options. And the majority plan to put in place additional contractual, that was the biggest one, as well as technical safeguards, a close second, and many organizational safeguards as well. So I think it's important to consider, as companies grapple with this complex landscape, what government authorities are telling them about their case-by-case assessments, what are acceptable additional safeguards in this realm, and what are some of the next steps we can expect. So in recent weeks, there has been a huge amount of action that I think is worth considering and discussing here. As Vivian mentioned, the European Data Protection Board issued its draft recommendations on additional safeguards just a few weeks ago. And the EDPB recommendation leaned really heavily on technical safeguards. The primary one being encryption of data, both in transit and at rest. So the EDPB also suggested contractual and organizational safeguards along the lines of those industry had already been adopting, such as commitments to notify the data exporter of access requests where legally allowed, as well as commit to challenge those requests where there are legal grounds to do so. But I think that the important piece here, and the one that privacy professionals are grappling with to the greatest extent, is that the EDPB pointed to instances, including where a recipient is subject to FISA 702, where only technical safeguards which render the data inaccessible would be viewed as sufficient in their eyes. So importantly, on top of that, the board said it could not come up with any technical safeguards for instances of processing by a foreign recipient in the clear by cloud processors or for general business purposes. So I feel almost the need to pause here and just point out that those are really big instances that affect a lot of data flows. Some might even say the vast majority. On top of that, the EDPB also suggested it was inappropriate to rely on what it termed subjective assessments of the likelihood of government access to data rather than to assessments of laws, a position which seemed to contradict the risk-based approach taken in the GDPR. So in other words, the EDPB said that it didn't really matter whether the company had never been subject to a government access request or whether the data at hand was of no interest to government authorities, and that what companies should be focused on in their assessments is the laws themselves. As a result, the initial draft, and I think it's important to point out it's a draft subject to public consultation, which has already been extended, has caused a lot of concern among companies who've relied on contractual measures and assessments of government access risk since July, having few other options, as the board itself acknowledged, particularly when encryption does not align with their business model. One day after the EDPB's recommendation came out, the European Commission released its new draft of standard contracts, which Vivian pointed to as well. And that new set of standard contracts pointed to the EDPB's recommendations and incorporated some of them. But importantly, the Commission's draft seemed to support risk-based assessments of government access likelihood. Along with these developments, of course, I think it's important to note that the US government and European Commission have seemed to intensify talks on an enhanced privacy shield while the EU and UK negotiate a Brexit adequacy deal. Some privacy experts have suggested that the Schrems II decision makes adequacy decisions the only real path forward to enable data flows out of Europe, while I would say others have suggested it exposes the flaws and politicization of the adequacy approach. So I think I want to, as I conclude and step back and look at the bigger picture and dissect these developments, I want to look a little bit more closely at some of the issues that Vivian raised. And I think it's important to recall that this is a global, not a transatlantic issue. The EU's adequacy regime has pushed countries around the world to adopt mini GDPRs, many with their own versions of an adequacy model. So some countries like Israel have grandfathered the EU's adequacy list. Others like Colombia have created their own list, grandfathering the EU's list and building on top of it. Japan, for instance, has tried to thread the needle with a hybrid option that includes mutual adequacy, as well as an embrace of the APEC cross-border privacy rules model. These replications of the EU's approach and other adequacy determinations raise some important questions following the Schrems II ruling. And I think the most immediate question there is, what about onward transfers of data from these countries to the US and elsewhere? So must these countries, foreign countries now, follow EU jurisprudence as well? And, if so, that might not be particularly welcome by them as sovereign nations. But if not, it would seem to hold different countries or companies to different standards, depending on the root of their data. I think more importantly are some bigger questions. As more countries consider data protection legislation, and again, Vivian touched on just how many of those we've seen, including India and China, the challenges for companies operating across borders will only become more complex. So are companies then called on to adopt more and more country-specific and divergent contracts and rules governing and granting jurisdiction to different authorities for different subsets of their data? And does that force data segmentation by jurisdiction? Do companies face a choice, as we discussed earlier, between data localization or ignoring the rules if encryption is not an option for their business model? So again, turning to some data that we have collected, in just 1 year, we've already seen some evidence of a trend toward data segmentation. Despite general agreement among democratic governments on data protection principles, companies are finding it increasingly tough to implement a global data protection program. We see them marketing data localization to their clients. But I think, again, here, an important question to pose is whether localization actually even achieves the aim it is intended to post-Schrems. In terms of addressing surveillance concerns. So earlier this year, we saw the CNIL issue an opinion that Microsoft's plans to host public health data in Europe ran afoul of Schrems II because the CNIL said that the US government could still demand data from a US headquartered company. Now, even if not followed by the French court, this opinion calls into question the efficacy of data localization in addressing that surveillance concern. I think perhaps more importantly, US and EU intelligence cooperation and information sharing seems as strong as ever, and somewhat at odds with the discussion of these issues when it comes to commercial actors. Just a few weeks ago, the US Privacy and Civil Liberties Oversight Board, for instance, issued a statement on its review of the terrorist finance tracking program administered by the US Treasury. The PCLOB found that 40% of database queries performed by the Treasury over the past 3 years were on behalf of EU member states, and 75% of the data shared with foreign governments have been with EU member states or institutions. So, that's how some of these things are playing out on the surveillance side, but I think it's also important to consider how the growth in data transfer restrictions and localization around the world affects, as again, Vivian teed up for us, data protection in practice and how it affects individuals and businesses. So I I will conclude by making some of the same comments that were teed up earlier, that as the UK develops its new digital strategy post-Brexit, and as EU and US diplomats launch a new transatlantic agenda, I think these are some important questions to consider, including because there's much that companies themselves can't control. The UK, I would say, seems likely to be cast in the role of mediator or perhaps marriage counselor between US and continental Europe on data protection. While a cooperative approach to data protection has proven a bit elusive even among the EU's own member states, I would argue there is a much bigger challenge and need for multilateral cooperation ahead. If we do not want to cut off our society's communications with each other, policymakers will need to consider how to approach this issue in a more holistic, sustainable, and multilateral way. And I think they will need to consider binding principles in 3 tracks: commercial data protection, national security and law enforcement protection, and data flows. And these principles already exist. I think what we've seen is that with Schrems II and these types of discussions, it's at their intersection where we have problems. Most importantly, the relevant stakeholders in the commercial and intelligence spheres from around the world will need to be at the table to discuss not just laws, but practice. And the OECD and WTO could offer some useful venues. Pragmatically, of course, we need a short-term fix, and I think there are good women and men privacy professionals around the world trying to do their best here, but left scratching their head as to what is legally acceptable at the moment. So thankfully, diplomats are working toward that short-term solution, but longer term, we need a path that brings certainty for businesses and individuals. I think it is helpful that the UK ICO chairs the OECD committee working to bring governments together toward that goal right now. And hopefully the UK can draw on its own somewhat rocky but instructive experiences with adequacy to chart a creative path forward. So with that, let me turn it back over to our moderator, and thank you so much.
Caitlin, thank you very much for that. Sorry, a slight finger trouble on my part. There's now an opportunity to ask some questions of our last 3 speakers. I'm going to kick off with this question here, and forgive me if I'm getting the name wrong, Małgorzata Klaczynski. Because, Caitlin, you basically said you don't want to get into certain circumstances where countries can't communicate with one another. You know, there shouldn't be a handicap or a block there. This question says, what about receiving communication through Gmail from a client, where already the data has been exported to the US through Gmail? We have no means to inform the client of the data transfer. What should we do then? What kind of precautions do we need? What's your thoughts on that, Caitlin?
Well, thank you very much. You know, I want to be a little careful about offering any legal advice, and I expect my 2 colleagues that are practitioners might actually be better placed here to opine. I guess I would just say that I think there has been a lot of work across sectors in recent years to approach notification creatively. I think you know, encryption in many of these cases may also be an option, but I wonder if I can actually kick that back to some of our practitioner panelists here.
Well, that's probably a very sensible move. Vivian.
Thanks very much for that football there. I got it. And I'll hand it over to Toby soon as well. I think we need to remember that there's always been a distinction about data that transits and data that is actually processed in a particular place. So one of the phenomenons, of course, with the internet is that, and when you send information across the internet, it gets broken down into lots of little packages and goes lots of different little routes, and then sort of reaccumulates at the destination. So if it's merely just transiting and it happens to transit through 16 countries, it doesn't mean that it's stopped there. And so what we should actually be looking at is rather the service of the platform, rather than the fact that it is transiting, as the case may be, because that's a slightly different issue altogether. Toby, I see you nodding. What have you got to add?
Agreed. Well, it's back to the definition of processing. And in these instances, if it happens to transit third countries, that's not the issue here, so long as it's secure. It is purely transiting. So there's no obligation to notify the third party that you're using a Gmail server that might happen to have gone via States.
Okay. I'm going to point this question at you, Toby. This is from Joan Darragh from STV. Some regulators, brackets Ofcom, require broadcasters to report employee diversity and demonstrate improvements. There's therefore a legal obligation there. Would you still rely on legitimate interest for Article 6, or would legal obligation take precedence under those circumstances?
Yeah, thanks for that, Mark, and thanks, Joan. Regulators requiring broadcasters to do this now, I'm not familiar with the specific requirements being applied by Ofcom here, but assuming they exist, and I don't know whether they are legal obligations or purely industry regulation, but I think it would then be entirely reasonable to rely on Article 6.1c, which is a legal obligation. The broadcaster's Article 9 exemption will then be a 9.2b, which is an obligation in the field of employment. And that, of course, means that they then have to apply the additional safeguards in Schedule 1, Part 4 of the Data Protection Act 2018. And if I sound like a walking encyclopedia, I've just been cribbing it and making notes, so I'm not that good. But the point being that that may sound onerous. I would argue that those requirements are probably still easier to manage than explicit consent. So from the point of view of the broadcasters, that wouldn't necessarily be a bad thing.
Vivian, you might Yes, surely can.
Yes. I was going to say, if I could just add to that, it's a question that we often get in the financial services sector, which is, if MiFID requires X, or if the Payment Services Directive requires you to provide details of the beneficiaries of a payment, etc., am I allowed to process the data? And where there's an explicit legal obligation to process or to provide or collect data, then you comply with the explicit obligation. It doesn't mean you ignore privacy. It means you apply privacy to the explicit obligation. So you would still apply the principles of data minimization and security and such like, but you can, if the law says, actually then collect the information. So it's not intended to conflict. Sometimes there can be more challenging circumstances where it's more of a balancing act, and that's where we often go to regulators for clarification. But as a rule of thumb, that tends to be the approach.
Okay, I'm going to ask you a follow-up question again, Vivian. This is again from Joan Darragh, STV. Apparently, health and safety experts are advising them, especially production companies, to retain COVID-related data indefinitely in case of a claim. Your eyebrows shot up there. What's your view of the data is collected?
Well, if anyone ever says retain data indefinitely, my eyebrows will shoot up.
Immediately, yeah.
It's one of the data protection principles is that you can't retain data for longer than is necessary. So indefinite just feels completely unnecessary. There's very few obligations where indefinite applies. And some of those where it does are, for example, for company and corporation records, because as a matter of law, you need to retain those forever. But there's very few obligations where you should retain things indefinitely. And what firms usually do in relation to record retention is you look at, is there an explicit obligation to retain? And if you've been advised to retain, then yes, there appears to be an obligation, but it needs to be reasonable and proportionate. And indefinite, I mean, unless it's carved in stone, I'd be absolutely flabbergasted that would be regarded as reasonable and proportionate. The reality is if you look at the Limitation Act, and how long individuals have or entities have in which to bring a legal action. And if you add a reasonable period of time on top of that, you're usually looking, the term of the incident plus, say, 7 years would be the maximum. So indefinite, just I think my eyebrows gave the answer. There you go.
Absolutely. Can I just chime in on that, Mark?
Yeah, sure.
I totally agree with everything that Vivian just said there. Just bearing in mind that you can retain the same data for multiple purposes. You might find that for screening at reception desk, you've got employees and visitors, and you're holding it for just 30 days in order to hand on to public authorities if there's a need to do so. You've then got your employees that, as you said, Vivienne, you're hanging on to maybe 4 or 6 years after termination of employment, and that's for defending a legal claim. It's quite possible that we'll discover that there is a nasty long tail in symptoms of COVID, in which case you might find HSE issue an instruction that treat it like asbestos, like hazardous substance records. But in the absence of that instruction, I'd completely agree that the 6 years seems entirely reasonable as the longest period to keep it.
Anything to add, Caitlin?
No, just to very much second what they said. And this was something that came up, I guess I would say, during my last life when I actually led a team administering the Privacy Shield. We were very careful, in fact, when we would look at companies' privacy notices, that they didn't have words like retain indefinitely. I think that harks back to an old era where folks thought if they just said something, they put it in their notice, then they could do it. And now there is, I think a much greater understanding that, no, that's just not acceptable.
This is an interesting question. It's hard to overstate the importance of data to the modern economy. Are we likely to see a degree of resource nationalism with data, just like with physical commodities like oil and diamonds? Toby?
I suspect so. We saw the Russian data protection law starting to force data onshoring. And it would make sense that countries that are going for a slightly more isolationist view of the world would choose to keep their data onshore. Within my personal experience, so we are a Turkish-owned company, so I have a lot of dealings with Turkey. And the Turkish data protection law requires consent for the offshoring of personal data. There are exceptions available. So those exemptions, if adequacy is in place, if you've got approved BCRs, those will also allow you to get round consent. However, the Turkish Data Protection Authority hasn't provided any opinions of adequacy, at least not of which I'm aware, nor has it approved any BCRs. So the reality is that to get personal data out of Turkey, we have to go and get consent. And you can probably spot how that sounds a bit daft, of going to each of your employees and saying, we need you to consent to offshoring your data. Ironically, that bit isn't prohibited under the Turkish law. As long as you have a record that they've okayed you to do so, that doesn't count as a coerced consent. So they're achieving that onshoring without explicitly saying that's what they want to do.
If I could actually pop in on that one as well, which is, this is very much the theme of the proposed Indian legislation, both for personal and non-personal data. There are definitions of critical data, for example, where it has felt that it is of such significant national importance that even with consent, it may not be exported. Now, this is draft legislation, but I think there's been lots and lots of comments received in relation to it, and concerns raised about what the implications might be. But in answer to the question, do we think that this is an evolving theme? I think I would have to say that, yes, I think it is an evolving theme, and one that, fuel has been added to the fire in terms of the COVID-19 experience, where countries are looking at their supply chains and their businesses, and looking at their interdependence with the rest of the world, and perhaps rather than looking to strengthen the bridges, many of them are looking to draw the bridges up, which I would suggest is perhaps not the advisable route. It would be to create more bridges, to create greater resilience and cooperation to ensure the safe flow of data and assurances, rather than to draw up the bridge, so to speak. But I think in response to the question, yes, data is so important, and jurisdictions are looking at it with much greater focus than ever before.
And Mark, could I jump in very quickly on this one as well? Just to add one piece, I very much agree with what's been said. I think we're seeing this trend, but I guess I at least have a bit of optimism here, because I feel like very often we're seeing this in the first drafts of legislation, sometimes even before it is tabled, like with the EU Data Governance Act. And then when thoughtful privacy experts and professionals come into the room and talk about how this can be done without that data sovereignty piece, sometimes at least we see a move back away from that. So at least a touch of optimism.
Okay, if we move on from India to China's upcoming data protection law, Ren Al-Mata has asked about that, talking about data sovereignty and things like that. In the Chinese context, Caitlin, protection for whom, from whom? If the concept of privacy as stands in this country apply sort of, can you pick it up and drop it down in China and make sense of it?
Yeah, I mean, I think that is an incredibly tough one. I think you've seen calls for democratic governments to come together. I think that is often specifically targeted as a reaction to the approach in China, and looking for other governments to come together and agree on principles. And I don't think that there has yet been a melding of the minds as to how to approach China. I think it's something that policymakers will very much have to grapple with. Perhaps the privacy specific principles and elements of their new proposal will help move toward that end. I don't know what to say. That is a complex one, but as a major player on the world stage, with a long and exalted history and culture, it will have to be grappled with in the years to come.
Okay. Do either of you want to add anything on that? I think the short answer is no on that one. Yes, you can see the noose yawning in front of you. I'm going to ask one more question, purely and simply because I love the way it's phrased. John Yao says, excuse the noddy question. If SCCs are to be supplemented by TPA due diligence on a case-by-case basis by the data exporter, who's going to be marking the work and declaring compliance? Who wants to handle that?
If I could jump in on that one, just with a few thoughts. I think this is a perpetual challenge in that, there are more and more onerous requirements, as we've all discussed, placed on companies to grapple with the intersection between commercial and national security. So in the first instance, I think governments need to help extract and separate these two issues and deal with the national security piece. But then separately, I think, one thing we've seen on the multilateral basis in recent years is the use of certification mechanisms, accountability agents, verification providers, and there may be a way to look at third parties as a way to kind of extend out and divest some of the very onerous tasks that sit on a regulator's shoulders, whether just to serve as initial dispute resolution mechanisms so they don't have to deal with the influx of individual complaints and can focus more strategically. So, looking at some of those third parties and how they could be leveraged may offer some help here.
Actually, could I add some additional comments to that? I wholeheartedly agree with Caitlin's comments. And there is an increasing burden on business. And I think this is one of the challenges with the Schrems II guidance and with SCCs, is that businesses are being asked to opine on issues that are well beyond the scope of what a business feels that they have the capability to do and is within their purview. So, an ice cream manufacturer, why should they be considering the national security laws of Canada or of South Korea, as the case may be? I mean, how? Why? In what capacity? It's just like it's very difficult to understand. And the other part of it is that actually my feeling is that we should be working toward accountability. If you're creating processes and legislation that requires you to be looking over your shoulder and to be looking at who is going to be, quote unquote, marking your work, well, the regulator doesn't have capacity to do that. And really, is that what it's all about? Is it about tick box compliance? No. It's about businesses being accountable and taking a risk-based approach to compliance to ensure that they're addressing the risks that are real and relevant and dealing with that in an appropriate way. And if it's not real and if it's not relevant, then it goes down the risk profile that an organization takes. And I think when you build that sense of self-responsibility, it builds trust, it builds transparency, and then organizations feel confident about demonstrating compliance. When the rules are so strict that it's impossible to comply and you're being asked to do things that are well beyond your purview, then it creates real concern. And I would suggest a much more tick box compliance approach, which is not about real compliance. And I think there needs to be a rethink in relation to that approach, because I just don't feel that it's particularly helpful and likely to be able to be adhered to. The extent of some of the guidance is such that I just have no idea how SMEs are going to achieve it. It's going to be one heck of a lift for large, sophisticated organizations to comply with. I don't know how SMEs are going to cope.
You're nodding along with a lot of that, Toby.
Oh, I am. I'm basking in the wisdom coming from Vivienne and Caitlin. I've got nothing that I could add to that.
Good man. Modesty in all things. Listen, thank you both. Thank you all three of you for your presentations this afternoon. That's been extremely helpful. Sorry if I haven't been able to get around everybody's questions, but Toby, Vivienne, and Caitlin, thank you all very much.
Thank you for the opportunity.
Thank you.
Right.
Cheerio. Bye-bye.
I'd like to take this chance to thank all the speakers today who've done an excellent job. I'm going to slip this in here because we've never actually done this before, but I've got a message here from Ken MacDonald, head of ICO regions for the Information Commissioner's Office. And Ken says, I was very disappointed that technical issues and COVID restrictions meant I couldn't participate in the conference today, and I'm very grateful to Maureen for standing in for me. Whilst she was told what I'd been expecting to cover, there was one thing which I couldn't ask her to say. And he goes on, this is the end of an era for the ICO in Scotland, as Mo is taking a well-earned retirement in less than a fortnight. Over the past 13 years and more, she's been driving home our key messages to our Scottish stakeholders and has quite rightly earned the respect of our colleagues and the wider DP community in Scotland. For my part, I couldn't have taken on the responsibility for our other two regional offices without having had her support. We've been through good times and bad times, happy times and sad times, and fun times and highly pressured times together. And she's going to be sadly missed by all of us, but particularly by me. And he says, thanks, Mo, for everything. Goes on to say, I can't ask you to show your appreciation in the usual way today, but instead, please do drop Maureen a note via chat and wish her well, which I'm sure you will. And for our part from Digit, we would also like to thank Maureen on behalf of Ray, Pete, and the Digit team for her time and support over the last 5 years. And everybody wishes her all the very best for her retirement. I'm sure she'll have a wonderful time, and just more time for the dogs can't be a bad thing. Thank you also to our conference partners, exhibitors, and sponsors. The exhibition zone is going to remain open for about another hour until 4:30. If you haven't had the chance already, please do take the chance to visit the exhibition stands and meet the sponsors. They've still got some of those competitions running and prizes. If you fill out the conference survey and give us your feedback for a chance to win one of 2 £50 Amazon vouchers, you can find the survey by clicking on the resource center icon at the bottom of your screen. That's next to the networking lounge. Now, this is not just a tick box exercise. This is what Digit uses to try and refine and hopefully improve future conferences. It only takes a few minutes, so if you could take the time, they'd be very much obliged. On-demand content of today's sessions will be available shortly and for the next 7 days. Upcoming events, Digit's next virtual conferences are Martech on the 24th of February 2021. This is a brand new event for people working in marketing, tech and management roles. And Scott Secure, our cybersecurity event on the 24th and the 25th of March. Registration is now open for these conferences. You can secure a place by visiting the Digit booth in the exhibition hall. One final thank you, and that of course is to you for attending this conference, albeit virtually. I hope you found it useful and that the information has been what you hoped it would be. For myself, Mark Stevens, thank you very much for your attention, and from all of us here at Digit, I hope you have a nice, peaceful and restful Christmas. Thank you again.